Malcolm Moore.
Thank you very much. You may be seated. Good morning. How's everyone this morning?
Good morning, Your Honor.
Gentry, Mr. Davis, Mr. Kern-Fuller, Ms. Tessier, how are you doing today? All right. I'd asked the attorneys to dispense with opening arguments in this case. However, I do know that there were some changes in the posture of some of the claims that were made, and I would like the attorneys to, first of all, state your appearances on the record, and then if you would, for the plaintiff to go over the causes of action that you're going forward, just name them. Don't need to argue them. I've heard a good bit of argument on those already. And then when we get to the defense, I'd like to also know what counterclaims you're still going forward on so that we've got a clear understanding as to what issues are being presented before the court during these hearings. So I'll give you a second to take a look at that. I'd ask you to dispense with opening arguments, but I think since we did have that change in the posture of the case, that we ought to be clear about what we're going forward on.
Your Honor, Troy Tessier for the plaintiff, Anderson County, joined by Ted Gentry, Tally Parham, also from the White's firm.
Good morning.
All representing Anderson County. We also have Tom Allen, who's the chair of Anderson County Council, as our client representative.
Good morning, sir.
And just to try to answer your question, Your Honor, the plaintiff's claims, I believe, are all going forward. Let me find my amended complaint.
I listed some 11 of them on the notes that I took, and maybe I just should go over with you what I have, if you disagree with what I have that you're alleging an ethics code violation concerning the contract.
Yes, sir.
That it's void as a matter of public policy is the second one. That Mr. Preston violated the state and local ethics code. That Mr. Preston committed fraud. That Mr. Preston committed constructive fraud. Preston committed a negligent misrepresentation, that the actions of counsel constituted actions that were arbitrary and capricious, that Preston breached the contract, that Preston breached fiduciary duties, that the retirement system should refund monies paid to it, and that Mr. Preston has been unjustly enriched.
That's correct, sir.
Have I correctly stated the actions that you're still going forward on?
Yes, sir.
Okay. Any others?
No, sir.
Thank you. All right, for the defense.
Good morning, Your Honor. Lane Davis and Kern-Fuller.
Good to see both of you again. Yes.
Defendant Joey Preston. I believe that some communications with the court have occurred with respect to our tort-based counterclaims. We have reached a settlement, and those claims won't be part of the case. However, that does not impact our contract-based counterclaim arising out of the severance agreement, and specifically with respect to paragraph 8. In the case, there has been a limitation with respect to the damages that we're claiming. That limitation is that we are going to be pursuing basically the defense costs and defense fees arising out of breach of the covenant not to sue in the severance agreement. All of the income-based claims and
I'm sorry, the what based claims?
the lost income-based
Income-based
claims,
claims, all right.
and also all of the
I just didn't get that word. Go ahead.
all the reputational-based claims were racked up in the settlement that occurred.
So that's all out.
It's all out.
Okay.
And as a consequence of that, Your Honor, I think you may recall we had a limiting motion, and part of the reason why the court didn't rule upon that limiting motion was because of the reputational element of the damages. Well, all of that has been removed from the case.
Okay.
As a consequence, I'm hereby renewing our motion and limiting with respect to all those grounds, and ask the court that it limit the the scope of this case because I believe that that will greatly simplify what's before Your Honor.
All right, let's hear from the plaintiff concerning that particular issue.
One point, Your Honor, we agree with most of what Mr. Davis said about the counterclaims. The tort-based counterclaims have been removed. As Your Honor knows, you did sign a consent order as well, which strikes from the pleadings certain paragraphs of the breach of contract claim, which then focuses the damages there. We think it's still, Your Honor, premature to rule on the motion in limine, and really believe the court needs to hear some context and decide for certain what should stay or not stay in the case. I don't want to re-argue the entire thing unless the court...
Well, I don't want you to re-argue it either. I will, and I won't rule on that at this time, but I will tell you that, as Mr. Davis has said, if the tort-based counterclaims have been resolved, then the degree to which we would go into those matters, I think, would be somewhat limited. I'll just tell you that before we get there.
Yes, sir, and I think our position is going to be that there will be a distinction between reputational injury type claims and, for example, credibility, which will be an issue in this case regardless.
Well, again, I don't know where that'll lead, what that's going to lead us, so I will reserve my rulings in that regard. Yes, sir.
Your Honor, one more preliminary motion. At this time, the defense would move to sequester the witnesses.
Any objection to that from this plaintiff?
No, Your Honor.
Well, before I make that order, are there particular individuals that you think should remain in the courtroom to assist you with your case, the presentation of your case, that may also be a witness in the case?
No, Your Honor.
My understanding of the rule, Your Honor, is that primarily applies to expert witnesses, and if we don't have our expert witness here, don't think we need him. If we choose to try to have him present at some point, we'll let you know.
If I issue a sequestration order, it'll apply to anyone who you intend to present as a witness in the case.
And one last point on that, Your Honor, we do have Tom Allen is our client representative here. He is likely to be a witness, I think.
That's what I was referring to. Is there somebody that you want to keep in the courtroom that would be of assistance during the trial?
Yes, sir.
He's named Mr. Allen.
Well, yes, Your Honor, we would object to that. I mean, obviously, Mr. Allen is only one of 7 council members, and in addition to that, the county attorney is sitting right behind him. In addition to that, he's under subpoena. And in this case, Your Honor, we think that one of the most critical things that you're going to hear by way of evidence is that there's going to be, let's say, contrasting evidence from witness to witness about identical issues. And obviously, there is some danger with respect to the defense in this case if the witnesses are allowed to remain and
well, what they're asking for, though, is just for one person to remain who is considered to be their client.
Yes, Your Honor. Out of the county council members, however, I think I have Mr. Allen under subpoena, and I have Ms. Wilson under subpoena.
Well, I'm going to let them designate one. And so whoever that is, I'll let them have one.
Okay.
All right, so, and that is Mr. Allen.
Yes, sir.
And I assume obviously Mr. Preston's party, and I'll allow him to stay as well. All right, I then will grant the motion for sequestration of witnesses. If there's anyone in the courtroom who is a potential witness in this case, I'll be asking that you leave the courtroom at this time. I will caution those who would be involved in this not to discuss your testimony or possible testimony with anyone. As long as the trial is proceeding, that order will remain in effect whether you have testified yet or have not testified yet. In other words, you should not discuss your testimony with anyone during the progress of this trial, whether it's present testimony, past testimony, or future testimony. So anyone who's a potential witness in this case, I'll ask you to step outside, remain there until called as a witness in the case. Anyone remains in violation of the order, they will be denied the opportunity to testify.
Your Honor,
Yes.
Mr. Waldrep is going to be the first witness. I don't know if you want him to leave or stay.
No, he can stay, he's going to be the first. I believe that's going to be a problem. You may have a seat, Mr. Waldrep. You're going to be the first witness. Thank you, sir. Just have a seat back there, Mr. Waldrep, till you call. They may have some more things they want to go over with. Thank you, sir.
I'd be glad to be outside.
No, have a seat right there, fine. That's okay. Thank you, sir.
Your Honor, if it's helpful, both parties have agreed to try to pre-admit a bunch of exhibits. We each have a notebook that we'd like to offer
All
the
right,
court.
okay, thank you.
The segue, so we have a plaintiff's binder and a defense binder.
All right. Now, as to the documents that are in the binder, have both sides agreed to their admissibility?
No, Your Honor, we're about to cover that right now.
All right, let's
We
talk
have,
about that.
we have done as well as we could, Your Honor, in trying to agree to what exhibits are not objectionable to each side. And if I may, for the record, I can go through them right now. For the court reporter's sake and the party's sake, we can check off the ones that are not objectionable. We don't mean that you have exhibits that are, going to be objected to, but we'll leave those for a later time.
All right,
The ones, Your Honor, from the plaintiff's side that we have agreed that are admissible and should be admitted into evidence at this time are exhibits 1 through 5, exhibit 5A, exhibit 6 through 10, exhibit number 12, exhibit number 15, exhibits 20 through 22, exhibits 24, and then 26 through 31. And then it starts again, Your Honor. Exhibit 34 is pre-admitted. Exhibit 35 is pre-admitted. Exhibits 37 through 60 are pre-admitted. Exhibits 72 through 76 are pre-admitted. Exhibit 76A is pre-admitted. Exhibits 77 through 79 are pre-admitted. Exhibit 82 through 90 are pre-admitted. And I believe exhibit 94 is pre-admitted, Your Honor, from the plaintiff's side.
Defense agreed to the admission of those documents identified?
Yes, ma'am.
All right, did you get that, Pam? All right.
And to make it easier, Your Honor, I didn't give Mr. Davis a hard copy of my list with respect to the defense exhibit, so I'll go ahead and tell you which ones we don't object to from the defense side.
That's satisfactory, Mr. Davis?
Yeah, you can see how it is, right?
All right,
All right,
then,
go ahead.
here are the ones that we agree can be pre-admitted without objection from the defense binder. That's exhibit number 2, exhibit number 4, exhibit number 6, exhibits 10 through 13, exhibit 16 through 31, Your Honor. I believe we've reached agreement that there are certain notes that Mr. Bright, who's going to be a witness, handwritten notes that he had, and we just agree, I think Mr. Davis will agree, that we were okay with the admission of the ones that Mr. Davis wanted to admit, provided that all of his notes were admitted. The only exception, Your Honor, is exhibit number 32, which is a different animal, and we'll talk about that when we get to it. And we're okay with admitting these exhibits, Your Honor, with the sort of caution, I guess, that some of these notes contain hearsay and or even hearsay within hearsay. And so since it's a bench trial, we're confident that the court can sort out the value of such information.
I understand.
Your Honor, I agree that that is our agreement without stipulating to counsel's view of the evidence rules on the hearsay.
I understand. I won't hold you to what he said.
Sir. Then, Your Honor, we're okay with and don't object to the pre-admission of exhibits 33 through 50. Same is true for exhibits 52 through 61. We have no objection to the pre-admission of exhibits 67, 69, 70, 71, 80, 81, and 82. And we have no objection to the pre-admission of exhibits 85 through 95. No objection to the pre-admission of 97 and 100. No, 97 and 100, not 97 through 100. No objection to the pre-admission of exhibit 101, exhibit 104, exhibit 108, exhibit 111, exhibit 113, exhibit 117 through 120, and no objection to the pre-admission of exhibit 137. What we propose to do, Your Honor, is as we get to witnesses who have exhibits that we have an objection about, we make it as clear as we can to the other side and raise it with you at that time.
I understand. As he correctly stated, what we agree on.
Your Honor, he has absolutely stated our agreements correctly. Do you want to mention to him the agreements of that interrogation? Your Honor, in addition, we have an agreement about
What would happen in instances where, in this case, because it's somewhat unusual as far as posture, when the plaintiff or the defense, for example, calls a witness that is affiliated with the other side. For example, the potential council members who voted in favor of Mr. Preston's severance agreement. We think that underneath the rules of evidence that they should be arguably treated as affiliated witnesses, and that the plaintiff could cross those witnesses on their direct examination. And part of that agreement is also that on cross-examination, I'd be able to cross them as well. So you're going to have double crosses. That is the same agreement that we have going in the other direction. Everything that we agree to is a two-way street. And to the extent that during my case in chief, I call sitting council members, for example, Mr. Allen, Ms. Wilson, or Mr. Moore, that I'll be able to cross them on direct, and they as well.
If you'll just make me aware of that situation, I think I'll probably be aware, but be sure I'm aware of that. We'll live with that.
We wanted to mention that to you just because when you heard the examination, you may be puzzled as to why.
I understand. Well, since it's a non-jury hearing, we relax those rules somewhat.
Well, thank you, Your Honor.
Anything further that we need to take up in this a pre-trial matter? From the plaintiff's perspective?
Yeah, we agree with what Mr. Davis said about the crossing of witnesses, and we do have, as I noted, there are some Tom Bright notes that we did not object to the admission of. We have a few of those as well that I just need to give you some exhibit numbers for, but we can do that as
we do that as they come up. Anything further from the defense?
No, Your Honor.
All right. Plaintiff ready to call the first witness?
Yes, Your Honor.
You may do so.
Your Honor, Anderson County calls Bob Waldrep to the stand.
Walter, come forward, please.
Ready.
Raise your right hand, please. You solemnly swear affirm the testimony you give the court today in this case to be the truth, the whole truth, and nothing but the truth?
I do.
You will take the witness stand and state your name for the record and spell your last name, please, sir.
My name is Robert Waldrep, W-A-L-D-R-E-P.
That's your witness.
Thank you, Your Honor.
Yes, sir.
Good morning, Mr. Waldrep.
Good morning.
Would you tell us, please, where you currently reside?
I reside at 2703 Jackson Square, Anderson, South Carolina.
And how long have you lived in Anderson County?
In Anderson County since 1964.
Where did you go to school, college?
I went to the University of South Carolina.
And after did you graduate?
I did.
What did you do after graduation?
I went to the United States Navy for 2 years.
And what did you do in the Navy?
I was a journalist and a radar man.
What years did you serve in the Navy?
Beg your pardon?
What years did you serve in the Navy?
That would have been 1959, 1960, I believe.
Did you receive an honorable discharge?
I did.
Thank you, Mr. Walker, for your service. What did you do after you left the Navy?
I applied to law school at the University of South Carolina and was accepted and finished law school in about 1964.
Did you pass a bar exam after you graduated?
I did.
Where did you pass the bar?
In South Carolina, Columbia.
Have you been licensed to practice law in South Carolina since you passed the bar?
I have since 1964.
How would do you have a law practice today?
I do.
How would you describe your law practice?
It's a general law practice. My daughter and I practice together right across the street from the courthouse.
Have you ever served on the Anderson County Council?
I have.